What is selective incorporation? Also, you may have noticed I'm going for the ultra low profile look. It's my quarantine world, and I have these pretty sweet moles, so just keep that in mind. It'll add ambiance to the video. You may be asking yourself, what is selective incorporation? Well, good news, because we're going to try to explain that. Selective incorporation is the Supreme Court retroactively applying the Due Process Clause of the 14th Amendment and relating it to the Due Process Clause of the 5th Amendment. Here's how they're related. The 14th Amendment says states will do this due process, and the 5th says that it's Congress doing it. So technically, the Bill of Rights, as they're originally written, do not apply to state governments whatsoever. And that's kind of terrifying because it means prior to selective incorporation, state governments could, infringe on your rights all day, every day, and there'd be no consequence. They could walk into your house and quarter those soldiers, which is so controversial. They could restrict your free speech. They could restrict your ability to practice faith. They could certainly take your guns. And then over time, the Supreme Court has applied the Bill of Rights, incorporated the Bill of Rights to state governments using the 14th Amendment's State Due Process Clause and relating it to the 5th Amendment's Due Process Clause. So you're probably wondering, example time. So examples. With the rights of the accused or criminal defendants, one of the required cases that kind of everybody on earth should know is Gideon v. Wainwright, which is hilariously about this guy named Clarence Earl Gideon. And surprise, he's of course from Florida. He supposedly breaks into a pool hall in Panama City, Florida. Nobody knows why, 8 a.m. of all times, and was suspected as having walked out with like a bottle of wine and some change or something. And he's in trial, does not have representation, does not have a lawyer, and he couldn't afford one. And so this goes all the way up to the Supreme Court. Obviously, he gets railroaded. It goes up to the Supreme Court, and they say he should have had a lawyer. So the Supreme Court literally says that the 6th Amendment's right to an attorney also applies to state governments, because that's would be nuts if you couldn't get a lawyer at the state level, which makes a lot of friggin' sense. Of the required cases, that's the only right of the accused one that I can imagine coming up. If the First Amendment comes up, all those cases you have about the First Amendment, like Engel v. Vitale, Wisconsin v. Yoder, New York Times, Tinker, Citizens United is a First Amendment case. Those are not incorporation cases. So you kind of have to dig somewhere else. Like Gitlow is a great example. It's one of the first selective incorporation cases ever. And then if privacy is brought up, I know Roe v. Wade is our privacy case from the 14th Amendment. That is not a selective incorporation case. Privacy would be maybe the exclusionary rule in Mapp v. Ohio, where we see that evidence which is obtained illegally by police officers or law enforcement cannot be used. It's not admissible in court. There are obviously ways to kind of get around this, the plain view doctrine or clean hands doctrine, use that private investigator or something. But, it's all fun and games until you don't have a lawyer under the 6th Amendment in your state government. Hope you guys have an awesome day, and maybe this will help clarify selective incorporation.